morning. Good morning, everyone. My name's Craig Nard. I'm the Director of Center for Law, Technology, and the Arts, and welcome to this wonderful conference on art repatriation. You know, whether it's the Elgin marbles or a bust of Nefertiti or an Etruscan bracelet or a weary Heracles, these and many other cultural objects have pitted powerful governments such as Turkey, Italy, Greece, excuse me, and Egypt against some of the most prominent museums in the country. The Louvre, the Getty, the Met, and of course our very own Cleveland Museum of Art, one of the top comprehensive museums in the country, or as we say, that gem across the street. Who owns these cultural objects? Who should own them? And what does the law have to say about our analysis? How can the law inform our analysis in addressing these important questions? This conference will address that issue and many others. It's a timely and exciting conference. And as Center Director, I have to take the liberty to say I'm excited for an additional reason, is that conferences like this fit perfectly into what we've been trying to do at the Center for several years, and that is to build a high-profile, first-rate program in law and the arts, whether through conferences like this, whether through a robust curriculum, internships, or our recently launched joint degree in law and art history and museum studies. So it's an exciting time indeed. Before I turn it over and step aside, I do want to recognize a few people for their hard work in organizing the conference. Sarah Coles of the Journal of Law, Technology, and the Internet, she and her fellow students, and my colleagues Eric Jensen and Del Nance for putting together such a great conference and recruiting a distinguished group of participants. And with that in mind, I'll turn it over to Sarah.
Hello, everybody. On behalf of the Journal of Law, Technology, and the Internet, I'd like to say thank you for coming and welcome this morning. This symposium has been a year of planning for all of us, and I'd just like to again say thank you to all of the members of JOLTI for all of your help and support throughout this last year. I'd also like to say thank you to Craig Nard for making this happen, and to Professor Nance and to Professor Jensen for all of your help throughout this entire year. Well, let's just get started. We'd like to start out today with Professor Jennifer Niels from right here at CASE, the Art History Department. In addition to teaching classical art and archaeology here at CASE since 1980, Professor Niels has guest curated 2 major international loan exhibits, including Goddess and Pallas. I am very bad at pronouncing Greek names, so I'm going to let Professor Niels say that one for you. And Coming in the Age of Greece, Images of Childhood in the Classical Past, and edited and co-author their catalogs. Her most recent books are also names that I'm very bad at, and the British Museum, Concise Introduction to Ancient Greece, and Women in the Ancient World. She has served as Vice President for Publications in the Archaeological Institute of America and area editor of the 7-volume Oxford Encyclopedia of Ancient Greece and Rome. And so I'd like to welcome, please, Professor Jennifer Niels.
Thank you, Sarah, and thank you to the law school for inviting me to talk on a topic that's near and dear to my heart, because I am an archaeologist, not a lawyer. And so I'm going to talk today about antiquities in particular and the repatriation of antiquities, some of which have been part of or involved with a site where I have worked for 15 years in central Sicily, namely Morgantina. And I just start off with this rather amusing cartoon about the Met Crater, because this is really the object that kind of launched repatriations from museums. It was bought in 1972 for what was thought an extraordinary amount at the time, $1 million by the Metropolitan Museum of Art, and it was just recently, well, it was returned to Italy in 2006. The cartoon shows the dealer Robert Hecht paying off the Tombaroli, the tomb robbers, as Hoving dashes off with the vase. We should have a new cartoon now where Philippe de Montebello is handing the vase back over to the Italian authorities, but that hasn't showed up. It represents, this image kind of represents the two sides of the conflict, the museums which want to buy and display important cultural artifacts, and those archaeologically rich countries who consider their artifacts as part of their natural patrimony. And I like to phrase it for students by saying, when you go to Italy and you go to a museum, the Uffizi, you don't see Picasso. You see all Italian art in most Italian museums. Same thing in Greece. They don't collect world art the way Western or our museums and some European museums do. They collect their cultural heritage. So it's different to them. It's not just beautiful art on the walls. It's part of their history and their culture. In the United States, of course, we do, I'm not going to talk about NAGPRA, the National Grave Repatriation Act, Native American Grave Repatriation Act, but we have laws now in this country that involve repatriation to Native peoples of their cultural artifacts and their skeletal remains. Now, a common headline in the paper, I mean, this is the most recent one that I've seen, but it's been going on for years, Toledo Art Museum to give back rare jug. We see this all the time, and what museums are now doing is voluntarily giving back objects, often even without evidence on the part of the country of origin, although this is an Etruscan vase, and Etruscan vases are only found in central Italy. So it's pretty clear where this came from. How long it had been out of the ground is another question, but it was bought in 1992 and was returned this year, sort of 82, and returned this year by the Toledo Museum of Art. It represents the changing moralities in this field. We would never tolerate Elgin's despoilation of the Parthenon these days. The idea that no longer does might equal right. We have the Hague, we finally signed the Hague Convention, which means that we will not take cultural property in times of war. And just because something is legal, I'm sure all you know this, it doesn't mean that it's ethical, as we've seen in the recent investment banking scandals. So I believe, I believe that repatriation is here to stay. It's not going away, and we're going to see a lot more of it. This Etruscan vase that I just mentioned was smuggled out of Italy to Switzerland. Switzerland and Italy, I'm happy to say, now have a bilateral agreement in which they will not allow objects from Italy into Switzerland without an export permit. But in the bad old days, this happened all the time. And another thing that happened a lot is that the record of provenance, where this came from, was forged. I happened to work for 6 years in the Cleveland Museum of Art. I met dealers in Europe, and they had mimeographed sheets in which they would sign with the illegal provenance right there. They just had copies of them, signed them, handed them to you. That satisfied everyone at the time. Brian Kennedy, the museum director, said, of course, the right thing to do is return this object. We knew we'd likely lose it and we'll miss it. And one of the great downsides for museums, of course, is that their insurance does not cover the cost. This vase is now valued at $665,000. I really don't know what Toledo paid for it. Now let's go to my exhibition A here, the country of Guatemala. And I don't know if I can do this here. Do I have a, no, I don't have a pointer, but we're talking about Petén, northern Guatemala, and the site of El Peru that you see at the top. Just last year, 2012, a tomb was discovered here of a very important person, Lady Cabell. And in that tomb was an alabaster vessel that you see here with a portrait head on it, and fortunately a glyph which identified this woman as one of the greatest queens of Mayan civilization. She was actually had a title of supreme warrior, which meant that she had more authority even than her husband. This was scientifically excavated by David Friedel and immediately published, so that we had all the information about this tomb. What's particularly interesting about this tomb is on the plaza, there was a relief with her image, which is now in the Cleveland Museum of Art. Acquired in 1967 after being cut into 19 suitcase-sized pieces and smuggled out of the country. This is what the website says about it. It doesn't give its origin as Guatemala or the El Petén site, or even identify this woman. The counterpart to this, her husband, is on another stele which was acquired by the Kimball Museum in Fort Worth in 1970. And their website identifies the site, Petén region, El Peru, Maya culture, and also, which is very important to us archaeologists, is that it says where it came from, namely from the dealer John Stokes in New York, who also supplied the Cleveland piece. But more and more museums are now, fortunately, putting on their websites the provenance, which means the dealer in these cases, for these works of art. Unless you think that this kind of looting has actually stopped with the 1970 UNESCO agreement on cultural property, which I think we'll hear about from Josh Knerly. The DeYoung Museum in San Francisco bought this Mayan stele in 1999. It was in 11 pieces, also from Stokes. That's not on the website, but it's on. You can find this information in some of those websites that I put on the reading list that I handed around, like Looting Matters and some of those other places. Okay, my exhibit B comes from the site of Morgantina, where I have worked as an archaeologist for 15 years. And there have been two rather stunning examples recently of repatriation of antiquities, in fact, estimated as to be $22 million worth of antiquities. This is our little museum in a 17th century convent. It consists of a lot of small pieces that have been excavated since the 1950s by Princeton University, little bits of buildings, terracottas, vases, things like that, all what we would call Kleinkunst, small objects, artifacts, in the museum. But it has now acquired two rather major new objects to display in the museum as a result of a local judge named Silvia Raffiota, who doggedly pursued evidence given by affidavits from local inhabitants of this small town. It's a very small town, Idoni, and went after, pursued these leads, and eventually forced two major museums to return objects to Morgantina. I contrast his book, The Cacha ai Tesori, The Search for the Treasures, The Hunt for the Treasures, with Hoving's 1975 book, which you may remember, The Chase, the Capture, Collecting at the Metropolitan, which talk. So roles have changed now. Now we're hunting to get things back as opposed to the pursuit to acquire them for museums. This is one set of objects. This was a really fabulous silver hoard of 15 pieces, which was acquired over 3 years by the Metropolitan Museum of Art, 81, 82, and 84. There are two interesting objects in this hoard. On the lower right here, you see two horns, horn-shaped objects, probably once part of a helmet. And in the middle is a little cylindrical object. Turns out these were almost as valuable as the inscriptions on the Mayan stele, because one of the affidavits of the witness to the looting mentioned two horns, very unusual in a collection of silver. And the cylindrical object has an inscription on it that says eupolemos. Eupolemos. Polemos is the Greek word for war, and the Met translated this as from the war. So this was some kind of hoard buried during the time of war, captured in war and buried or whatever. However, Eupolemos is the name of a citizen of ancient Morgantina because we have a plaque which lists his name on it for a house contract. So the director of the excavation, let me just show you the protagonists in this case. We have the curator, Dietrich von Botemer, at the bottom, Robert Hecht, the dealer who brought this out of Sicily, and the museum director, Philippe de Montebello, on the right. And this was bought and eventually put on display at the Metropolitan Museum of Art. It was published, which led the director of our excavation to realize that this was probably from Morgantina, and he received funding from the Italian government to excavate in an area where the tomb robbers had been working, and he uncovered a house with a looter's pit in it and a 1978 coin, which shows that it had been looted in recent times. And so pretty much proof that this came from Morgantina. And now it is back, happy to say, in the Museo di Morgantina without a lawsuit, although we had spent many years proving, even the Met to this date doesn't admit that it came from Morgantina. And here you see some of the local citizens lining up to look at this material. My exhibit C is this statue in the far left of the slide of the Getty Museum, which is the famous so-called Getty Aphrodite. It's not a statue of Aphrodite. That's a more sexy name for it, but it's actually Demeter or Persephone. And the curator, who was instrumental in buying it, Marion True, who in 2005 was indicted by the Italian court on criminal charges, accusing her of participating in conspiracy that laundered stolen objects through private collections and creating a fake paper trail. And in November of 2006, this was the director of the museum at the time, Michael Brand, announced that 26 disputed objects would be returned to Italy, including this piece, which just went back last year, went back in 2011. And it's kind of interesting that the Italians went after a curator, because the curator, in a sense, was doing her job, acquiring objects for the museum, and it's the trustees and the director who presumably write the check. And in a letter to the trustees in 2006, True stated that she was made to, quote, carry the burden, unquote, for practices which were known, approved, and condoned by the Getty's board of directors. And again, a fictive provenance was part of this statue's story that had belonged in a family of a Swiss collection for 50 years, et cetera, which was blatantly untrue. But what's so interesting about this piece is that we don't have the name of the figure. We don't have made in Morgantina written on it, the way some other artifacts fortunately do. And there's no direct link to the site. And yet, the Getty eventually, post facto, did due diligence on this, brought in experts to not only authenticate the statue, but also to look at the material in which it was made, its limestone and marble, to figure out where that might have been quarried. They even had a pollen analysis done. They dug some dirt out of the armpit of this statue and did a pollen analysis. They flew in somebody from New Zealand, and all she had to say was this was buried in an area where there were nut-bearing trees. So that wasn't very helpful. So they really didn't have any proof where this came from, except that the limestone actually is found in southeastern Sicily, near our site, and very fine analysis of limestone. So eventually, without any real proof, but pretty compelling suggestive evidence, it was returned to Italy, and this is now on display in the Morgantina Museum. So it seems to me that what museums were doing, they considered this legal. It didn't matter, the ethics weren't important as long as it was legal, and it was the acquisition that was important, not so much the manner of the acquisition. And of course, the Getty now has a very firm policy about what it will buy, and a strict policy about provenance, as does the AAMD. Now, the Cleveland Museum of Art did return 14 objects to Italy, and in return, one of the benefits of this repatriation, one of the pros about it is that in return you get objects on long-term loan, wonderful objects on long-term loan. And the Getty has made hay on this. They've gotten some unbelievable pieces. The Cleveland Museum got these 4 pieces, which were from Locri, from southern Italy. And this brings up, again, this kind of issue of transparency because the labels say nothing. They say simply these are on loan, say nothing about why they're on loan, why they've come to the museum. And what's even more important is that these objects were found in a sanctuary of Persephone. They have an archaeological context, they have a history, we know their use, we know many other objects that were associated with them tell a whole interesting historical story. Museums are educational institutions. It behooves them to tell us this story in all cases. And I think they're somewhat failing in their mission not to be totally transparent and honest about these objects. So, my time, how am I doing? I started early. So I think there are really 2 choices facing museums, and these 2 statues illustrate those choices. You can either, in terms of bringing great objects from the ancient world to your audiences, which is the mission of museums. You can either buy an object of dubious provenance, not publish it, or even state the true facts about it on your website, which is actually one of the requirements of the AAMD, or suggestions in their guidelines, I should say. And hope for the best, hope nobody asks for it back or comes up with proof that it came from somewhere else. Or you can bring your audiences bring objects with a context, as the Getty has done in the case of this Apollo on the right, which is a long-term loan. And in fact, this beautiful other bronze Apollo was a statue that stood in the sanctuary of Apollo until the fateful eruption of 79 AD. And on that note, I would urge you to go see the exhibition currently on at the Cleveland Museum of Art on the reception of Pompeii. So I think to sum up on the pros and cons, certainly I applaud the mission of these universal art museums to bring some of the finest examples of ancient art to their public. However, they are liable not only to countries either suing or requesting repatriation of these objects if they have been looted, and I think we have to assume that these objects are guilty until proven innocent. And there's a financial loss because no one is going to compensate you for the millions that you have spent on this object if indeed it does go back. The pro side of repatriation is that now that we can have agreements with these countries who have rich archaeological remains, we can borrow their works, have them on long-term loan, spend probably less than we would on the acquisitions, and bring great art to the public. This is what the Getty's been doing, Boston and other museums, and this is, I think, a win for all of us to be able to see these objects in this country, have a chance to study them and publish them. So I think I'll end there. I think my time is up, and I'll look forward to answering questions later. Thank you. We can have individual questions now, apparently, ahead of time. Yes?
Is it a valid point for instance, the British Museum to make that if the Elgin marbles were returned, then Greece with its political instability and pollution might not be able to care for them as well as the British Museum itself has?
Okay, the Elgin marble is sort of the flagship of this debate. I have written about it, but I'll summarize it. You're bringing up the issue of stewardship. Who can better take care of these objects? And that used to be sort of the highbrow argument of the British Museum, well, we can take better care, all these Western museums. Of course, now we have one of the great state-of-the-art museums, 50 years newer than the the Duveen Gallery in the British Museum in the New Acropolis Museum. But the British always use this argument, but it kind of got blown out of the water 60 years after the limitation on some of their internal memorandum was, these internal memoranda were released that showed in the 1930s these marbles, these precious irreplaceable marbles, were scrubbed with metal brushes on the behest of Lord Duveen, who'd paid $1 million or so to build a new gallery, and he didn't like these dirty looking marbles. So he bribed it was completely against the regulations of the museum. They were only ever washed with water and a cloth, but they were brushed. And this was discovered by another curator and brought to light, but suppressed for 60 years. So their argument about stewardship doesn't really hold anymore. And I'm happy to say, as someone who spends a lot of time in Athens, that there's a lot less pollution now because of they've restricted cars and things like that. And the museum has state-of-the-art HVAC and whatever. The problem about the Elgin marbles is that we have a monument in dispersion. I mean, this is, I liken it to what if somebody had taken the Sistine ceiling and chopped it up and sent little bits here and there. A lot of it's in Athens, a lot of it's in Britain. There's a piece in Palermo, there's a couple pieces in Germany, the Louvre has a slab. I mean, this is all over the place. We can't understand the genius of that artist unless we try to put back as completely as possible this, brilliant achievement this is a 524-foot long narrative relief frieze. I mean, you're meant to read it, and it's dispersed. So it is my hope that someday those will go back to Athens. These are the crown jewels of Athens. I mean, and also I might add about some of these objects like the Guatemalan stele, these are site-specific objects. This was made to stand in front of this woman's tomb to commemorate her. The base is still there, the pieces that were chopped off the side are still there, and we have the pretty bit in a Western museum. It's like a trophy. Anyone else dare ask a question? Yes, Carol.
What is the sort of argument for the war looting and how that all these different sort of steps between where it came from and where it might be now?
I think you should ask someone else that question about World War II looting because that's not really my area of expertise. Maybe someone else will bring it up in their talk. Antiquities, except for the gold of Troy, for instance, which was looted from the Berlin Museum by the Russians. They took it as war reparations, hid it for years. Finally came to light, and it's on display in the Pushkin Museum. This was excavated by Schliemann, actually smuggled out of Turkey with no permission, and given by him to the Berlin Museum. Now 4 countries are claiming it. The Germans, because it was in their museum, the Russians, because war reparation, the Greeks, the Turks, because it was originally in Turkey, and the Greeks, the only reason I can think of is because they won the Trojan War, but so it's complicated. Yes?
You made a strong case for repatriation. What scenario, can you envision a scenario where you can make a strong case for retention? What would be the strongest argument? Of course, that depends on the artifact or the cultural object. But what would you say if you had to sort of put yourself in the other position, the strongest case for retention?
I think one of a strong case for it would be the political situation of the country. I mean, we'd be hard pressed to send things back to Afghanistan or countries that are at war, and even Guatemala. I mean, for that matter, I'm not sure what the political situation is currently, but I think it's problematic. So if they were in danger, and to be perfectly frank, I mean, Turkey has had things, they had to actually sue to get things back, and they've since been stolen from the museum. I mean, so you don't want to put the objects in danger.
So the stewardship argument does have some persuasion as long as the facts.
Yes, yes, I think he asked about the stewardship. It actually does in some cases, but more and more I think it would behoove us to help those countries protect their antiquities, improve their museums. We archaeologists do this all the time in the countries where we work, improve security, improve conditions so that they can put this material on display. But that would be the one case where I think I would be reluctant to, if it potentially could cause the loss of an important work of art. Okay, thank you.
Thank you, Professor Niles. Our next speaker is Josh Knerly from Hahn, Loeser, and Parks. Mr. Knerly is a partner. He's the co-chair of the Nonprofit Institution Practice Group, and from 1993 through 2008, he's the managing partner and chief executive officer of the firm. He is legal counsel to the Association of Art Museum Directors and has represented the AAMD as an invited speaker at the Prague Conference of the Holocaust-Era Assets, town meetings of the United States Department of State, and the Fair and Just Solutions Symposium of the Netherlands Restitution Committee at The Hague, and on numerous occasions before the Cultural Property Advisory Committee of the United States. He has been a frequent speaker and panelist at the ALI ABA Museum Law Conference and a guest lecturer here at Case Western Reserve University School of Law, as well as other law schools and universities. He has represented museums, universities, business entities, and collectors on various matters, including cultural property, Nazi-looted art issues, and complex art transactions. He has served as an arbitrator for the American Arbitration Association, the International Center for Dispute Resolution, and International Chamber of Commerce. He is listed as one of the 2007 through 2013 edition of the Best Lawyers in America for Nonprofit and Charity Law. Mr. Knerly holds an A.B. degree from Bowdoin College, an A.M. degree from the Fletcher School of Law and Diplomacy, and a J.D. degree from here at Case Western Reserve University. Please welcome Josh Knerly.
Thank you for that fulsome introduction, which is a lot more impressive than probably what I'm going to say, but in any event, the news media over the last few years have had something of a feeding frenzy with respect to the topic of today, repatriations of antiquities by American museums, and I think there are some fair questions that can be asked with respect to this relatively recent phenomenon, including, do museums do this because of ethical reasons or legal reasons, and why is it that only American museums seem to be doing this? Now, not only are the answers to these questions complex, but there is a lot of imprecision around the rhetoric used to discuss this issue, starting with the very word repatriation itself. Repatriation literally means, and this is the way UNESCO, by the way, defines it, in the context of cultural objects, the return of an object to its country of origin. And I hope you will see through this discussion, even that simple term is filled with complexity. If you look at some of the objects that were sent by U.S. museums to Italy over the last few years, you will see that some were actually made in Greece and shipped to the Greek colonies in southern Italy, so that in sending them to Italy, they were not actually returned to their country of origin. Others on this panel no doubt will address the issue of ethics, and Professor Niles did so, but I hope to provide some context and explanation with respect to the law. And the law in this area is extraordinarily confusing. There is an event in the past which does have significance, both ethical and legal, in connection with this discussion, specifically the promulgation of a 1970 treaty, commonly known as a convention, by the United Nations Educational, Scientific, and Cultural Organization, commonly known as UNESCO. The 1970 UNESCO convention was drafted in response to the perception that looting, in particular of antiquities, but also other types of property, was an increasingly serious problem throughout the world. This problem of looting is complex. There is no single cause, but UNESCO itself has attributed looting to a number of factors, including the fall of colonialism, the significant increase in interest in arts and cultures of a broader area of the world, and the explosion in the art market, although frankly I think this is as much effect as cause. Just as an example of the latter, in 1979 and 1980, Sotheby's had a turnover of approximately 242 million pounds. 10 years later, that turnover was 1.96 billion pounds. Now, the law in this area is informed by general legal principles, specific statutes, and court rulings. And if you take nothing away from my remarks, I hope you will leave with a greater appreciation of the complexity of the law in this area and the challenges that anyone contemplating the acquisition of an antiquity faces in attempting to evaluate the legality of a purchase. But let's start with the basics, and they form part of the answer to the question of why American museums appear to be repatriating more objects than anybody else. Perhaps most important to an understanding of why U.S. museums have been in the news more than others are the different legal systems in the world. And there are two basic systems of law in the world, the English common law and the French civil law. We in the United States follow the common law. The United Kingdom and most of its former colonies follow the common law. Mainland Europe, because of the Napoleonic Wars, nothing better than a war to move laws around, follows the civil law. And most of the former colonies of mainland Europe also follow the civil law. So when something is stolen and subsequently moved in commerce, there are different legal results based on the two different systems. In the English common law, there's a saying that a thief cannot pass good title, which means that no one can acquire good title to an object once it has been stolen until the original owner recovers it. The civil law system says that even if an object is stolen, if it is purchased by someone who acquires it in good faith for value, they can be accorded a superior right of possession even against the original owner. In many civil law countries, there is a period they have to hold the object for this to happen, but at the end of the day, an innocent good faith purchaser may be able to defeat a claim by the original owner. So you can already see why claims to recover property brought in the United States might be more successful than a similar claim brought in a court in France, Germany, or Switzerland. Now, those of you who are lawyers in the room are quickly going to say to me, yes, but there are statutes of limitations that cut off those claims in the United States, and you would be right. Although statutes of limitations are not uniform throughout the United States, some are simple. In other words, after so many years, the owner loses the ability to reclaim an object. Some only run from the time that the owner knew or should have known of the whereabouts of the object. That's Ohio. And in the most museum-rich state in the United States, New York, the statute of limitations only begins to run after the claimant has made a demand for return of the object and been refused. So statutes of limitations are not always a bar to a claim for recovery. Any museum, when faced with a repatriation claim, has to evaluate whether or not the claim would be time-barred, and time-barred under the laws of any jurisdiction in which the claim might be brought. But there's another reason that repatriations occur more in the U.S. than anywhere else, and that's the nature of U.S. museums, which are for the most part privately owned, whereas museums in other countries are government-owned, and they often have specific laws protecting their collections. You heard Professor Niles talk about the Elgin marbles. Well, one of the reasons the Elgin marbles is not going back is because under the laws applicable to the British Museum, they prohibit the removal from the collection of the Elgin marbles and their deaccessioning. So it would take an act of Parliament in order to make it happen. Now, in order for there to be a legal concern about possible repatriation, there has to be a claimant, and the claimant has to have a legal right to the object. And this is another very complex area of the law, because a foreign country's claim to a cultural object can arise in a number of different aspects. Now, the easy one is an object that is stolen from a national museum. It does happen. Those claims are brought, and although rare, they usually result in the return of the object. But over the last 100 years or so, source countries in particular have at varying times passed laws which purport to declare various types of cultural property to belong to the nation. And those declarations can include property already in the possession of the state, in private hands, and undiscovered, either underground or underwater. As American lawyers, we often have a hard time understanding these laws because if passed in the United States, they would in large measure be unconstitutional. But they can be perfectly valid under the laws of the country where they are adopted. For example, Italy in 1939 passed a law that any archaeological find or object of antiquity belongs to the Italian state unless a party can establish private ownership pursuant to a legitimate title that predates 1902, which would be unconstitutional in the United States. Now, these laws have been recognized by the United States courts as vesting title to objects so long as the object is then illegally removed from the declaring country after the effective date of the declaration. Some of these laws are relatively clear, relatively easy to find. Many, however, are extremely difficult to find and interpret. They're not clear in their language. They're often successive enactments that evolve and change the concepts of ownership. I'm still looking for an English translation, by the way, of the law of Uzbekistan. So if any of you are Uzbekistani scholars, come talk to me afterwards, please. So not only do United States courts recognize these laws as forming a basis upon which a foreign country can make a claim in a U.S. court, but these laws have also been recognized for purposes of various criminal and customs laws in the United States. In the 1930s, Congress passed a law now known as the National Stolen Property Act, which was designed to discourage principally the interstate movement of stolen cars. The law prohibits transportation in interstate or foreign commerce, the selling, receiving, possession of stolen property having a value of $5,000 or more if one knows it to be stolen. That's the knowledge requirement. Now, in the 1970s, federal prosecutors began to use this law in order to prosecute traffickers who participated in the illegal removal of antiquities from countries that had declared themselves to be the owners, and then brought them into the United States. Famous cases involving Mexico, Guatemala, recent ones involving Egypt. More important for our purposes, objects that have been transported or sold or possessed in violation of the NSPA are subject to forfeiture to the government, even in the hands of third parties. But the National Stolen Property Act is not the only criminal law that has been used recently in connection with cultural property. There's another federal law called the Archaeological Resources Protection Act, which was designed to protect archaeological material found on federal lands. But it has an interesting provision which says that it is a violation to transport a stolen archaeological object in interstate commerce if the property was excavated or removed in violation of any rule in effect under, this is a quote, state or local law. Now, in a tour de force, I think, of expansive interpretation, government lawyers have argued that local law means anybody's law, including a foreign country's law. This provision was actually used a number of years ago to seize objects from museums in California, which the government claimed to have been illegally removed under the laws of Thailand, local law. Another use of the criminal laws is in connection with customs. Customs law provides that it is illegal to bring a stolen object into the United States if doing so is, quote, contrary to law. And here the customs law grafts on the National Stolen Property Act in order to provide a basis for both potential prosecution, but more important, the seizure of an object that is brought into the United States if its movement across U.S. borders constitutes a violation of the National Stolen Property Act. This was the basis for a forfeiture brought by Customs against a New York hedge fund manager who had purchased a gold fiale from a dealer who had apparently sourced it in Italy, moved it to Switzerland, and then to the United States. Another customs law that is used in connection with cultural property deals with declarations on import. When you bring a cultural object into the U.S., even though it may be exempt from duty, you still have to declare it. There's a customs declaration that requires information, including information about the value of the object and its country of origin. If there's a misdeclaration on the customs form, which is deemed to be material, the property can be seized. And these customs seizures are problematic for museums and any other collector because customs can seize the object no matter where it is found and in whose possession it is found, even if the possessor was completely innocent with respect to the customs violation. They can follow this object forever, basically, wherever it ends up. Now, we need to make a distinction between these cultural patrimony laws that I talked about that can form the basis for any number of U.S. actions and export laws. One of the basic rules to remember in this discussion is the United States does not allow its courts to be used to enforce the police laws of another country. And in the context of cultural property, that means that if an object is illegally exported from one country and brought into the U.S., absent a rather tricky exception whereby illegal export results in automatic vesting of title in the state, and there's a Guatemalan case that actually involves this, the foreign country cannot sue in a U.S. court for its recovery or for unpaid customs duties. So you can see that the landscape is complex, replete with criminal laws and civil laws and forfeiture provisions. And of course, a foreign country can always just come into the United States, as Professor Niles indicated, Turkey did. By the way, they're the only country that appears to have done this, other than, I think, India in the 1950s, and sue to recover a stolen object. They rarely do it because it's expensive, it's time-consuming, and it's a lot easier to go to the federal government and ask the federal government to use either the National Stolen Property Act or ARPA or the customs laws and use the power of the judiciary that way. So, but what about the 1970 UNESCO Convention? Well, the United States signed that convention in 1971, one of the only art market countries to do so at the time, but didn't pass implementing legislation for another 12 years because there was a real controversy over how the convention should be implemented in the United States. Finally, in 1983, Congress passed a law called the Convention on Cultural Property Implementation Act and developed a very complex system whereby, at the request of a foreign country that has signed the 1970 convention, the United States can enter into an agreement with that country to prohibit the importation into the U.S., after the effective date of the agreement, of specifically identified cultural property, and they put a list up called the designated list, which is in the Federal Register, without a valid export license from the requesting country if the country meets certain specific statutory tests. Specifically, that the property is in jeopardy of being pillaged, the requesting state has made efforts to protect its cultural patrimony, if the U.S. imposes import restrictions in concert with other countries that have a trade in the objects, so that we're not going it alone, if you will, that would be a substantial benefit to deter the looting, and that there are not less drastic remedies available. These are known as the 4 determinants. Now, the law created a committee to handle these requests and make a recommendation to the president, and then the president can enter into these agreements. They're known as MOUs, or Memoranda of Understanding. There are currently 15 MOUs in place, and despite what I've said about the U.S. courts not enforcing foreign export laws, in a way that is what these MOUs do, albeit implementing import restrictions. So one would have expected, by the way, that these MOUs would have supplanted the legal recourse to things like the National Stolen Property Act or customs laws. Nothing could be further from the truth. Since the passage of the CPIA and the promulgation of these MOUs, less than a handful of objects have been recovered using that law. At the same time, hundreds of objects, I hasten to say, by the way, not from museums, have been recovered using the National Stolen Property Act or the customs laws. Now, you could say that for the person collecting antiquities, this could be pretty simple. Just get provenance, history of the ownership, back to 1970, when this UNESCO convention was passed, which supposedly created this watershed, and everything should be okay. And that is to some extent what the Association of Art Museum Directors, the major policy-making body for art museums, has suggested in their guidelines for the acquisition of archaeological materials and ancient art, with certain exceptions. But a provenance back to 1970 does not necessarily protect the acquirer. If there is a foreign cultural patrimony law that predates 1970, that is the law that has application for an ownership claim. And while some countries like Italy have said that they will not enforce laws that predate 1970, except with respect to objects that have left their country after 1970, other countries have tried to use earlier laws or decrees as a basis for making claims for objects whose departure from their country long predates the 1970 convention. And those countries are becoming not less, but rather more aggressive in their claims. There's a complaint that was filed by the federal government in connection with some objects that came in from Egypt, and in the course of the complaint, when you read it, the federal government argued that Egypt had an ownership laws back as early as 1875. So, at the risk of leaving you with more questions than answers, let me pose some, because if you look at the current state of affairs from a policy perspective, whether policy as to cultural objects or policy as to the regulation of marketplaces, and with respect to cultural property, I would submit you can look at this both ways, both from the standpoint of the national patrimony that Professor Niles referred to, but there's also that $1.96 billion market that was just Sotheby's, and so you can multiply that by tenfold, both in terms of today and the marketplace. And part of what the law is supposed to do is to bring the ability to be able to have a regulated market. So if U.S. policy is to control the import of cultural objects from foreign countries through the admittedly complex process under the Cultural Property Implementation Act, are we accomplishing that goal by using the criminal laws and the customs laws to actually control such movement? Does it make any sense that we do not enforce the export laws of foreign countries, except through the CPIA, but we allow U.S. courts to be used to enforce foreign cultural patrimony laws through the National Stolen Property Act, the Archaeological Resources Protection Act, the customs laws, and in particular the forfeiture proceedings that can be used under those laws? Yes, I understand as a lawyer that they're being enforced are violations of U.S. laws, but in fact what we have done is to engraft the foreign legislative enactments onto our legal system with no control by our Congress. And if laws relating to commercial activities are supposed to encourage open trade and bring finality and predictability to the marketplace, has the United States done so in connection with the antiquities art market, which is now subject to the alphabet soup of the CPIA, the NSPA, ARPA, and the customs laws? And is the alphabet soup and the patchwork of laws used because, unlike most countries, the United States has no Ministry of Culture? So with these unanswered questions, I'm happy to answer questions, as long as I don't have to answer the ones I posed. Sir.
If you could craft a federal law to address some of these ambiguities, what 3 key points do you think it ought to have?
Well, I didn't mention this at the time that the Cultural Property Implementation Act was passed, they actually introduced legislation in order to clear up this issue of whether or not you could use the National Stolen Property Act, and it died in committee. The customs laws are the customs laws, and I don't think I would actually touch those with one possible exception. But the idea that the concept of the Cultural Property Implementation Act really ought to be the way in which we deal with these countries, I think has a lot of value. So the concept that we would look to that process in order to determine what is and is not stolen and what is permitted to be brought into the United States. Now, having said that, it shouldn't be 15. I mean, if that were the sole way that we would regulate cultural property in the United States, it shouldn't be just 15 MOUs. I mean, and when you take a look at the countries with whom we do not have memoranda of understanding, which are rich in archaeological resources, it doesn't work. So it doesn't work from the standpoint of the CPIA, and it doesn't really work very well from the standpoint of the criminal. We ought to sort of pick one or the other. Yes. Oh, well, this is the softball, though, right?
Well, actually, I agree with everything you said about the description of the law. So we're agreeing.
Okay.
But I two things. One is when you mentioned the differences between civil law and common law, you had a qualifier on the civil law that after some period of time
Right.
is going to vest.
10 years in Germany.
And in a lot of these cases, we have experts debating what the law of Uzbekistan, I guess that's going to be coming down the pike, right? So we have experts debating what the law actually says. And it seems to me that in a lot of those civil law nations, that there is a requirement to take advantage of the 30-year prescription period or what have you, that the original acquisition be made in good faith.
Right.
And I think
Yes,
there is
yes.
some
Does have. I think I
ambiguity.
said it had to be a good faith purchaser for value.
So I think there is some ambiguity, in terms of how people speak about the civil law period. But my other question for you has to do with Nazi boulevard, so not what we've discussed, which I actually think is a different ballgame.
Certainly, both legally and ethically.
Yeah. But there was a draft piece of legislation that was being kicked around in committees in Congress. And I was wondering whether you might be able to speak to that. I didn't know if you were involved.
Oh, you're talking about the immunity bill?
Yes.
Oh,
That
yeah.
would impact Nazi boulevard. So I was wondering if you could speak to that.
Well, if you're talking about the one in terms of loans of art, yes, I'd be happy to. But I guess I have to give you quick context. When a foreign lender, museum, private party, whatever, lends a work to a U.S. museum, there is a statute that the U.S. museum can utilize in order to immunize the work of art while it's here in the United States. the policy behind this is that the ability to be able to bring cultural property into the United States for the benefit of the public is more important than a potential private claim against that property. And to encourage that movement, you can go to the State Department. The State Department can issue a determination that there's a whole bunch of factors. And once they issue that determination, then no court may issue any process having the purpose or effect of interfering with the property. Which is great. So the works come here, they're immunized, they're on the wall. Even if there's a claimant, it goes back. But there's a case that occurred a number of years ago in which the claimant brought an action against a foreign sovereign museum in the Netherlands, and they didn't go after the property. Actually, that's the public report with respect to what they did says they didn't go after the property. If you read the complaint, they did go after the property, but we're not going to get there in any event. But what they did do was they sued for damages. And so the works went back, but the case was then pending for damages. And the district court found that there was jurisdiction under what's known as the Foreign Sovereign Immunity Act, which generally immunizes foreign sovereigns from suits in the United States, but has an exception, and it's called the commercial exception and the international taking exception. By the way, this is more than you ever wanted to know, but you can't, without this background, I can't answer the question. Anyway, so they brought this suit. The district court found there was jurisdiction because they found the loan of art to a nonprofit institution in connection with an exhibition of art was commercial activity. So this, needless to say, did not make art museums happy, especially after they settled the case on appeal. They got 5 of the 14 works that they were asking about, which then sold for over $50 million at Sotheby's, as I recall. So that's sort of an incentive to claimants and claimants' lawyers, as you can imagine. So the Association of Art Museum Directors got very concerned about this and introduced legislation which passed the House in the last session in order to, in effect, get rid of the district court case and say that when a work comes in, if the State Department grants immunity, which is a political process, so they don't have to grant immunity, there's no requirement whatsoever. There are laws around the world that are automatic immunity, but not the United States. Then not only can you not sue to get the object, but you can't sue for a damage claim. But there's an exception, and the exception is with respect to Nazi looted art. So that if a work did come into the United States, that if there were a claimant, the claimant would still be able to sue for damages in the event that it was here. So it got passed in the House, died in the Senate. It's now being rediscussed to be reintroduced, maybe with some little language changes. So, I can't tell you what's going to happen, but it's not a dead issue at all. Let's put it that way.
And I don't have the language in front of me, but you described it as an exception for Nazi looted art, but I think our definition of Nazi looted art might be different. Because when I read the exception, it seemed to me that it would shut down claims in countries other than Germany and Austria that I would probably put in the category of Holocaust era.
Oh, yeah, because it's the Nazi government, it's the government in any of their controlled countries during the period that that's true. So
in the attempts to tweak it, is that going to be addressed? Do you have any information?
Well, my hope is that it can be tweaked in a way that will satisfy most. It's not going to satisfy everybody. For instance, there are people who argue, well, wait a minute, there should be an exception for cultural property. There are people who wrote and said, this is crazy. There absolutely should be an exception for cultural property. And by the time you get through with all the exceptions, you don't have a rule anymore. But the reason why, by the way, there should not be an exception for cultural property is, let's assume for the sake of argument that the British Museum lends the Elgin marbles to the Metropolitan Museum of Art. Now, who's going to make a claim? Who's the claimant against the Elgin marbles? Greece. Now, do we think it is a good idea as a matter of policy that the United States courts should be used to litigate the claim by Greece against the British Museum in connection with a loan to the Metropolitan Museum of Art? I don't think so. Somebody else has got to argue that. That shouldn't be played out in the federal court in New York simply because it was an art loan. So the cultural property exception, I don't think it's going to happen. The Nazi looted art, I mean, that's a matter of discussion as to what the right way to do that is. So, aren't you sorry she asked that question? Any other questions? So thank you very much.